This is Jennifer Signieri coming to you live from my home, and this is Workers' Compensation Talk, where we get down to the brass tacks and address all of your burning workers' compensation questions. This Facebook Live format is where we try to address your questions and explain the answers in a way that is hopefully simple and helpful. The area of the workers' compensation law to be covered may vary, but the format is always the same. We have a given topic, we discuss it. You can type a general question in the comments, and I will try to answer them while we're talking, whether live or even after a live session if you leave a comment afterwards. A little bit about me. I have been practicing workers' compensation law for over 10 years. I am board certified by the North Carolina State Bar. I also practice with a damn good team of attorneys at Johnson & Groniger, and I know I speak for all of us when I say that we like sharing our knowledge and our experiences with injured workers, and hopefully in order to empower you during this process. And that's part of how this Facebook Live Workers' Comp Talk format came about, is from our love of doing that. To that end, if you know anyone who will be interested in this episode, do them a favor, tag them in the comments, share this to your personal profile or your groups. You can also like and follow us on Facebook so you receive ongoing notifications about future episodes, because there will be future episodes. But anyway, before we get started, I just want to give the obligatory legal disclaimer. What I will talk about today is legal information and isn't necessarily intended to be legal advice for a particular claim or case. But if you hear something discussed and you would like to have a longer one-on-one discussion about your claim, call our office. We would be happy to talk. It's as part of a free consultation. Our phone number, through the magic of social media, is there. 919-240-4054. I know that one of the favorite parts of my job is just sitting down, so to speak, talking with people, getting to know them, learning about their legal problem. And I know that I'm not alone in my office, so please do call. We're happy to do it. It costs you nothing. And you can also contact us on our website at www.jglawNC.com and use the contact form and chat box, and we'll call you. So today's episode is about medical treatment. Unfortunately, it's a broad topic and not at all straightforward in workers' compensation claims. Many people are used to going to the doctor when they're sick or injured. Hopefully they have health insurance and they use that to pay for the visit, and that's the end of the deal. One of the first and unexpected issues that arise when someone is hurt on the job is simply getting the medical treatment that they need afterwards. So during this episode of Workers' Compensation Talk, I'm going to cover three things. First, I'm going to talk about the workers' compensation carrier's right to direct medical treatment. Second, I'll talk about what is covered in workers' compensation medical treatment. And then third, I'm going to talk about the exceptions to that workers' compensation carrier's right to direct medical treatment. And we'll also include a discussion, a part of the discussion about getting second opinions and how to ask for them. So first, after an on-the-job injury, it isn't as simple as going to a doctor for your injuries and then passing on the bills to the workers' compensation insurance company. Sometimes it can be that way. It's, say, a clearly covered injury that requires immediate emergency treatment or surgery. But by and large, it's unfortunately just not that straightforward. Under North Carolina law, the workers' compensation carrier is given the right to direct medical treatment in an accepted claim. So that's right. If they have accepted your claim, then they get to say where you receive treatment because they are paying for it. Most of the time that means anywhere a person goes for treatment of their injuries is going to require authorization, prior authorization by the workers' compensation carrier. And so, in fact, I'll often hear that an on-the-job injury happened and the injured worker goes somewhere and the medical provider won't even see them because they don't have prior authorization by the workers' compensation carrier. However, oftentimes there are huge delays associated with getting that authorization. Sometimes that's because the workers' compensation carrier wants to do an investigation. They want to conduct an investigation. They want to talk to you about how you get hurt on the job. They want to talk to your supervisor. They want to talk to any witnesses. They maybe want to get your recorded statement or get your prior medical records if you injured a body part that you've previously gotten medical treatment for. They want to do all of that they want to do all sort of that initial work before they ever give you medical treatment, which none of that is helpful for you just getting the treatment you need after getting hurt on the job. More often than not, I see three common scenarios arise when someone is injured on the job. First, there is, the most straightforward, if it can be that straightforward, where someone has a traumatic injury that requires truly emergency treatment. This is the situation where somebody's hurt, they're taken by ambulance from work, they go to the hospital, the emergency room, maybe they have surgery right away. In those situations where the need for the medical treatment is clearly related to a workplace accident, the workers' compensation carrier is going to authorize the treatment after the fact. And the medical providers really aren't going to question anything because it's an emergency situation. So, that's kind of an exception. The other two scenarios I see, and this is far more common, is first, for instance, where somebody's injured on the job, they report it. They report the injury to their supervisor. The workers' compensation carrier maybe hasn't even gotten notification from the employer that an injured worker got hurt, and they don't have any of that the background information that they need, the investigation work. The workers' compensation carrier may go ahead and authorize maybe an urgent care visit while they are doing that investigation, and so they'll go ahead and authorize sort of just really simple urgent care visits without necessarily accepting a claim. So that's one scenario. The other scenario I see is where, and this is really not uncommon at all, where somebody is injured on the job and then they don't report it because a lot of folks feel like, well, I'm not going to become a problem. I'm not going to mention it. I don't want to have to fill out a lot of paperwork. And so I'll just wait until the morning and see how it feels. I'll go home, I'll take some ibuprofen, and I think this pain will go away. And then, days later or the next day, that's when the pain hasn't gone away and they realize that really they needed to get treatment. And that's when they call their supervisor and they mention it for the first time. And in those delays, sometimes, depending on the employer, they will authorize an urgent care visit. So, more often than not, though, I think the workers' compensation carrier starts to get concerned that because of the delay, that the injury didn't really happen on the job. And so they may not authorize it at all. And they'll just go ahead and start doing their investigative work to verify that they are responsible for any need for treatment or for the actual injury. So because not every injury is an emergency situation, there is more often than not a delay in getting medical treatment and associated with an on-the-job injury. And that happens initially, again, because the carrier wants to do its investigation, but then it even happens after the fact because they want to verify that the treatment that you're requesting has actually been referred by the doctor while you're getting treatment. If you say you need a lumbar MRI, then they want to make sure that there's a referral actually on the books from the doctor saying you need that. So there are delays initially, and then there are delays even along the way because the workers' compensation carrier wants to verify that certain things have been done. In short, for just about every time someone with a workplace injury needs treatment, there has to be permission from the workers' compensation carrier to be seen by a doctor in order for them to pay for it. So one way you can move things along in getting some of the treatment is to report the injury right away. And, you know, even if you don't think it's going to amount to much, report the injury, maybe keep a screenshot of the text that you sent to the supervisor, letting them know you got hurt, or keep a copy of the email that you sent to your supervisor so that if it becomes an issue later on, you can eliminate any doubt that the pain you're talking about is related. So that's one tip. Assuming the workers' compensation carrier is authorizing your treatment, though, you should go to their doctor's appointments, in most cases, at least to begin. There are options. But if you simply decide not to go to their doctors and just go to the doctors you want to go to, maybe use your health insurance, you're going to run into a few problems. First, the workers' compensation carrier, when they eventually decide to accept your claim or not accept your claim, when they eventually want to direct your treatment, they're just not going to pay for your treatment or any treatment that they've decided to pay for. They're just going to say that you're just not agreeing with them directing treatment. Second, if you try to use your health insurance, the health insurance carrier is likely going to be pretty annoyed that you used your personal health insurance when a workers' compensation insurance carrier likely was responsible for your treatment. And the other thing to be mindful of is that the Workers' Compensation Act actually says that the refusal of an employee to accept medical compensation when ordered by the Industrial Commission will bar an employee from further compensation until the refusal ceases. Okay, so it's not always going to be the case that the Industrial Commission has actually ordered you to get treatment, but the fact that that is in there in the Workers' Compensation Act should lead you to understand that this right to direct treatment, at least initially, is something that's going to be taken seriously at the Industrial Commission. And you got to at least give them the initial ability to direct your treatment. So we know that they get to direct your treatment. What's included in the medical treatment under the Workers' Compensation Act of North Carolina? Medical compensation is actually defined in the Workers' Compensation Act of North Carolina, and it's defined as meaning medical, surgical, hospital, nursing, rehabilitative services, including, but not limited to, attendant care services prescribed by a healthcare provider, vocational rehabilitation, and medicines, sick travel, other treatment including medical and surgical supplies, and it even includes artificial members at the end of a healing period and replacement for those artificial members when it's reasonably necessitated by ordinary use or, it says, medical circumstances. A lot of legal jargon, but the takeaway is the medical compensation is broad, and it's meant to affect what we like to say, or what the law terms as to affect a cure, give relief, lessen a person's period of disability or the amount of time someone's out of work because of their injury. And two forms of medical compensation that we often have to educate folks on is the right to be reimbursed for out-of-pocket prescription expenses and mileage reimbursements. For both of these types of medical compensation, there are actually forms available on the North Carolina Industrial Commission website. The North Carolina Industrial Commission is the state agency that oversees workers' compensation claims, in particular when there are disputes. And on their website, and I'll try to include their information there, www.ic.nc.gov, on their website, there's an actual injured workers page. And under the injured workers page, there's the claims forms page. And when it comes to mileage reimbursements and prescription reimbursements, the first form, the forms you want to look at are forms 25P as in Paul and 25T as in Tom. The first form, the 25P, assists you in obtaining your reimbursement for out-of-pocket prescription expenses. So basically what you want to do is you want to gather all of your receipts every time you had to go to the pharmacy, and for whatever reason, the workers' compensation was not authorizing it and you had to pay out of pocket. Gather all of your receipts, fill out the one-page Form 25P, include it with include the receipts with the Form 25P, and then email or fax that over to the adjuster for your claim and ask to be reimbursed. The form is meant to streamline the process and help make it easy for the adjuster to go ahead and reimburse you. The second form is called the Form 25T, and that's to assist you in obtaining mileage reimbursements for travel to and from appointments that are 20 miles or more. So it has to be over, and by the way, it has to be 20 miles or over before it's reimbursed, and the rate of reimbursement per mile changes each year. So on the Form 25T, the rate of reimbursement is actually on there for each year. And for the year 2020, the mileage reimbursement rate was 0.575. So if you travel 23 miles round trip, it's over 20 miles. If you travel 23 miles round trip for a doctor's appointment, then you'll be reimbursed 23 miles multiplied by 0.575, which is $13.23 rounding up, right? So really easy thing that can be done is going on the website, downloading these two forms in PDF format, and then keeping a copy as you go, keeping a tally as you go either to an appointment or as you have invoices, and then sending that to the adjuster. And it's a good idea to make sure that when you send it to the adjuster for your claim, you keep a copy of your actually having sent it either by fax, with a fax confirmation receipt, or an email, so that there can never be some sort of, argument that you didn't send it. You can easily, say, well, it was sent on this day. I'd like to be reimbursed. So we know by and large that the workers' compensation carrier gets to direct treatment in an accepted claim. And we know what medical compensation is. Let's talk about the exceptions. Now, this right of a workers' compensation carrier to direct medical treatment isn't without limits. First, and maybe this is obvious, if the workers' compensation carrier is denying your claim that an injury is related to a workplace accident, then you don't have to go to the doctors that they send you to. If they haven't accepted it, then you can choose to go to your own doctors. You can go anywhere you want to for treatment and then appeal the denial. Before you start going anywhere on your own, you should at least provide notice of the injury to your supervisor and the workers' compensation carrier. You should give them an opportunity to direct the treatment and to deny it if that's what they're going to do. That way they can't say, well, they would have given you some treatment, or they would have directed treatment had they known. You just want to, at least on the face, give them a heads up, give them some notice. If they deny your treatment again, then you can proceed to go on your own. You can file a hearing request with the North Carolina Industrial Commission. At that point, you will likely want to talk to a workers' compensation attorney to appeal that denial as soon as possible. But that's an exception to the having to go where they tell you to. It's denied. There is, oddly, there is a provision in our Workers' Compensation Act that does require you to submit to a one-time independent medical evaluation, even though your claim is denied. If you are filing a hearing request, seeking to compel the workers' compensation carrier to pay you for your claim, even if they've denied it, they get their shot of sending you to a medical provider at least once. So there is also an exception to the exception. They don't get to direct your medical treatment when it comes to a denied claim, but they do get one shot. They do get to send you somewhere at least once. So be mindful of that. The other exception to a workers' compensation carrier's right to direct treatment is in an emergency. So let's say you're hurt in the job on the 10th of the month, you notify your employer of the injury, but then you never receive authorization to receive treatment anywhere. And you are in excruciating pain and you present to the emergency room for relief. That bill arguably is the workers' compensation carrier's responsibility, even though they didn't get to direct treatment. If they just sit and not authorize treatment after having notice of your injury, after having notice that you need to be seen, they don't get to just benefit from the delay. If you truly are in an emergency situation, you are in ongoing pain, there's a good argument that they should have to pay. Now, good practice would be to let them know, obviously that the injury occurred and that you're in excruciating pain and that, their delay is making things worse. But that's an exception. You don't have to suffer needlessly. It should be an actual emergency, though. Other exceptions to the workers' compensation insurance carrier directing treatment includes the right to second opinions. So if you have an accepted claim, you have the right to 2 second opinions, and both are supposed to be paid by the workers' compensation carrier. One is an opinion on the rating, and that's where you obtain an opinion with a doctor of your choosing to provide a second opinion on the rating to the injured body part. So, assuming you have an accepted claim and the workers' compensation doctor has treated you and released you, very often at the end of treatment, the workers' compensation doctor will assign you a rating. It's a number, it's a percentage. And that number and percentage is sent to the workers' compensation carrier adjuster, who will look at the Workers' Compensation Act statute on ratings and figure out what additional compensation you are due for the injury to that particular body part because of your workplace accident. The second opinion on the rating is a situation where you want to get another opinion because you think that maybe that rating is on the lower side and you think that you're probably due more compensation. So that's one option, is a second opinion on the rating, typically at the end of your treatment. The other option is a second opinion for independent medical evaluation. And this second opinion examination is done if you feel that maybe the workers' compensation doctor hasn't really helped or hasn't given you all the, you want to know what your other options are. Maybe the workers' compensation doctor you felt like was dismissive of your complaints, or maybe you felt like the workers' compensation doctor didn't do everything to address your pain. So one thing to be mindful of when requesting this type of second opinion is that workers' compensation doctor or workers' compensation carrier has 14 days to agree to your chosen doctor. And if they do not, you can go to the Industrial Commission and try to compel them to authorize your second opinion. But to obtain either of these second opinions, it's a good idea to request them in writing to the adjuster. And it's really that simple, to just request them in writing. It could be an email, it can be a fax to the adjuster. That way you have a specific date where you've requested the second opinion. You will want to specify if the second opinion is for a rating or for an independent medical evaluation, because that'll be the first question you get. Is this a second opinion on the rating? Is this a second opinion, for more medical treatment? What is this? The adjuster will want to know. The other thing you'll want to specify is the specific doctor that you want to do the second opinion. If you do not specify a doctor, and I've had this happen, and I wasn't representing the person at the time, the adjuster will just make a decision for you. And it's really ridiculous, because now they've had 2 workers' compensation doctors evaluate your opinion or evaluate your condition. So don't do that. Don't let them choose for you. If you got an attorney later on, they'd probably argue that you didn't get your right to a second opinion. But avoid the need for that and just choose your doctor. Be very clear about the doctor you want to do your second opinion for independent medical evaluation. So again, don't let that happen, and do your research about the kind of doctor that you would think might make a difference. So, tip of the week: delays in timely medical treatment is a major source of frustration for a lot of workers' compensation claimants. And one thing you can do after an appointment, but before you actually leave the doctor's office, is to ask for a copy of any referrals or scripts issued from the doctor that day. You don't need the actual pharmacy script that's going to be sent to the pharmacy to fill the script, to fill the medication that's been recommended by the doctor. You just need a copy of it. You want a copy of, the referral for the MRI, the referral to the orthopedist. You want a copy of those things because by and large, the adjuster, if they don't have it, will argue that they need to go get it before they authorize it. So you can eliminate some of that wait time by, before you leave the doctor's appointment, going to the nurse, the doctor's nurse, or going to the front desk and getting a copy. And then after the appointment, take a picture with your cell phone. Then email over, take a picture of the referral or script with your cell phone, and then email that over to the adjuster and ask for authorization. Doctor recommended I get a lumbar MRI. Here's the order. Authorize it. Let me know when it's scheduled. And then, that'll come in handy, for any delays too. And that comes in handy, by the way, whether you have an attorney or not, so that you can specify, listen, you all are dragging your feet. I gave you the referral. I gave you the script. So that's the tip of the week. If you provide a notice of the need for treatment or medication and they fail to act, then your claim that they are dropping the ball is much stronger. So keep that paper trail and make sure that you do that. So that's all for now on today's episode of Workers' Compensation Talk. Join us next time and bring your questions. This is Jennifer Signieri with Johnson & Groniger.